because of the weather that's coming our way. Looking at 8 to 14 inches, I guess. So I wanted to just do a short invocation up here, and Mr. McFarland, our Economic Development Director, will then introduce Mr. Rob Rosette of Rosette Law. Exciting team to work with. He's got a really outstanding group of Native American individuals who represent Indian country. I'm really excited about being part of this and the things that Brent and the team and everybody brings to this organization of ours. You know, personally, myself, I'm involved in a number of areas in our community. I'm the chairman of the Constitution Committee, and I work with Rob, part of Rob's team, and looking at effective strategies in governance and economic development. So we're exploring all the time on ways to move our nation forward into the future in many areas. Real broad-based approach to community development. So this morning when I woke up, I got up really early, and a thought occurred to me. You know, I'm a student of my language. Bungi, I know a little bit, and I wanted to share as best I can in the Shinabe Mo'in of our people what I was thinking, because I try to operate on a daily basis with a set of values that are going to encourage other people to step up to the plate and assume new roles and responsibilities and challenge old ways of thinking and doing that aren't beneficial to the progress of our nation. So I'm really excited to be doing that for our community, and I'm excited for myself because it's really an opportunity for me to grow. And I appreciate all the help and information and advice I get from my elders and community members that I'm involved with. So I just wanted to express my gratitude a little bit for the opportunity to be here today and to express a little bit of that ancient wisdom. And it goes, Chimanadu, Ije Manadu, Widu Kawashin, Ikin Gasawin, Zagi Iwin, Manishinabe, Kakinagibu, Miigwech. It's real simple, but for me, it has a real profound implications. Because what I was asking was to help me to understand Mishumasanane is washwe inwatchable. The lessons of those ancient stories and the values that are expressed in those stories that we need to reinvigorate within our community. So what I was asking for then was help in understanding how to express love that we used to be all about as Native people. So I wanted to express that much, and then the Kakinigegu which was just for everything that exists. I'm thankful. So that's what I wanted to say this morning. And I wanted to introduce Mr. Brent McFarland now to introduce Mr. Rob Rosette.
Thank you, Mr. Jack. Always a pleasure to share the stage with Richard. If you look at the program that we got Rob Rosette's resume. But I wanted to just say a few things for a minute about some things that aren't in there. Rob Rosette started with a law firm that bears his name. And, what I know about Rob's law firm is that he's been very active in hiring some of the most competent, intelligent attorneys that we've met in Indian Country. Not to mention just some really good people. Kerry Whitman is our attorney, and Kerry is the most knowledgeable community law attorney that I've met, arguably. Rob is also the reason started looking at the internet lending business and the internet businesses in general. And it was as a result of conversations that we had with Rob when he came to do the presentation here about the internet lending business that we began to pursue it and look for and started our business. This is kind of a small audience, which we're all really fortunate to be here, and to share that it's more people, because Rob is also an extremely bright guy who has a very far-reaching vision of what can be done for Indian country with regard to e-commerce and the internet lending as well as internet gaming. So we're really fortunate to be able to listen to what Rob has to say about that. And I just did have small numbers. I want to emphasize the opportunity that's presented to us. We're really fortunate to be able to hear what Rob has to say. So without further ado, Rob, I'm going to turn it over to you. And I want to thank you again for taking the time coming down here. Thank you.
Well, thank you for the nice introduction. I don't think this is a small audience. It's a good audience. One time I was speaking in Washington, D.C., and if there's one snowflake, everybody leaves. And I was asked to speak at an Indian Health Service conference on self-governance, and it started to snow a little bit outside, and people started filtering out, and it finally became my turn, and there was only one person left in the room. And I said, well, thank you very much for staying. I guess I'll still do my presentation. And he told me, well, the reason he was there is he was the next speaker. So we were the only two in the room. We just decided we'd just shake hands and leave. So this is not a bad turnout considering you got 18 inches on the way, right? Anyway, let me apologize first because I am an attorney, so my presentations just really get super legal in nature. I try to make them somewhat interesting, but I'm really going to just sort of delve into a whole bunch of law. And what I like to talk about is e-commerce on the Indian reservation, because really I think that's the future of economic development for Indian country. And it's especially exciting because tribes in rural locations, I'm a member of the Chippewa Cree tribe from Rocky Boy, Montana, and tribes in rural areas like my own tribe are now venturing into e-commerce, and like Flambeau. And we're learning that it doesn't matter where you're located anymore. The tribe's sovereignty online is as important as any other tribe in the country. So all of a sudden, you know, we can open businesses in the same location as Morongo or Pachanga or Foxwoods, or I guess I better watch how I refer to them, Mashantucket Pequot. So this is an area that, you know, our law firm, at least over the last 5 years, has really been attacking extremely hard. And unfortunately, you know, one of our first successful forays into this industry was with regard to online lending. And it's really easy to dismiss the legitimacy of the activity because a lot of people say, well, that's payday lending. And you know, that's the first hurdle we usually have to overcome, is most of the tribes don't offer payday loans. They offer short-term installment loans and small dollar loans. And many times because we let the customers sort of choose what their amortization will be and how to pay it back. They can choose, you know, 1 year, they can choose 6 months, they can go under 6 months and choose 2 weeks. So I guess by definition that can be a payday loan, but of course the tribes aren't forcing people to enter into these loans. The people sort of pick their payment plan and what works best for them. But we've got a lot of work ahead of us, you can tell, because of the negative connotations with regard to payday loans, if you will, even though that's not what we're doing. We're providing financial services and small dollar loans. But what's clear is the attacks on us right now, because of our limited success with regard to the online lending, it's an attack really on the entire sovereign model and the ability for tribes to engage in any commerce online. And that's why I entitled my presentations Moccasins Laced with Asbestos, a Modern Model of Commerce, is because and when I was in front of the Second Circuit not too long ago in the state of New York, the argument that I was making with regard to tribal sovereignty devolved quickly, where the judge recognized that, even though when they're arguing about internet lending, it really was a novel issue because it involved any activity over the internet. And after all, what if tribes sold moccasins online? And even worse, what if those moccasins were laced with asbestos? Then, wouldn't the state have a right to regulate that activity or be concerned that that product was being sold online? And to me, it demonstrates how hyperbolic and ridiculous these issues can become. But it's all the more important that we fight hard to preserve the long-term viability of e-commerce for Indian country. And really, that's where my presentation focuses on, is what tribes should do. I know that the topic was sort of the legal and political issues. So what I want to do is kind of talk about the legal and political issues that I see tribes should be focusing on as they get involved in e-commerce. And specifically, I guess, my presentation might be a little bit offensive because, as you know, the Lac-Mead-Desir tribe, who's a neighboring tribe and present here today, filed a lawsuit in the state of New York. And I hear all the time, particularly from lenders who work with tribes and their attorneys, that look, they really liked the California case that recently came down that said tribes are immune from suit, and they really liked this Colorado Supreme Court case where the state couldn't sue the tribe that was engaged in lending. But it's this New York case, doggone it, that the tribes brought that's real troubling to a lot of people and the attorneys. And I'm trying to explain back to them that, what they need to recognize is there's real differences between tribal sovereignty and our ability to engage in e-commerce responsibly and sovereign immunity, which, while it's an attribute of sovereignty, it's really an issue that the tribe should never focus on. It should be an issue of last resort and something that tribes should try to avoid at all costs, from my perspective. And so we'll work through my presentation, but my point is that tribes and their attorneys, as they engage in any e-commerce activity, need to focus on notions of sovereignty and not notions of sovereign immunity, to the extent that, well, let's go ahead and do this activity because nobody can sue us. So let's get started. I have a slide here just really on tribal sovereign immunity. And the word sovereignty, as you know, as tribal members and as tribal leaders, we hear it all the time. It gets thrown around loosely in council meetings. You can hear it, 10 or 20 times easy. That's our sovereignty, right? But a lot of people don't slow down and understand what the word really means, what the true definition of it is. And so when I think of sovereignty, I try not to use the word period. I always talk about governance. And more importantly, if you have true governance and you're developing economic development programs, and you're talking about nation building, developing infrastructure and putting real money, a real tribal economy, and the results from that economy back into your government, into your people, to instill pride and provide jobs and so on and so forth. And then, the real notion of sovereignty, and this is a Supreme Court case, is it's the ability for tribes to enact laws and be governed by them. So in other words, it's a concept that tribes have as governments. Private companies, people, nobody can actually enact a law and then use that law to govern themselves. That's something that's reserved for the United States, other foreign countries, state government, so on and so forth. And the reason that's important is because it sort of illustrates that, first of all, when you talk about sovereignty, you're talking about tribes as governments. But it's important to realize why we have that. And it's because tribes as governments have been here for time immemorial, as you know. Tribes predate the United States Constitution. So sovereignty isn't something that was given to tribes. Sovereignty is something that's always retained, that tribes maintain and continue to maintain since the United States was even formed. It's important to realize that tribes predate the United States Constitution. So The next point of sovereignty is because you predated the Constitution, you've got your own elements of governance, you pass your own laws, you have your own jurisdiction over your members. Well, where does that leave the state government? Well, the states don't have jurisdiction generally over our lands or our tribal members when there's activities occurring on our lands, generally. With regard to criminal law, that's different, but in the civil context, it's true. And so that's where the tension comes. And that's where sovereignty goes from something that we retain, but is constantly getting chipped away from state government. And it's easy to see when you look at sovereignty and economic development opportunities, sort of the tension that's created from really the three sovereigns. When I say the three sovereigns, I'm talking about the United States, tribes, and state government. Like I said, with regard to state laws, states, when it comes to various economic development activities, can either over-regulate an activity, or maybe they'll just outright prohibit that activity. And like I said, those state laws generally don't apply to tribes. And then with regard to federal laws, when you look at the federal legal system, they usually don't over-regulate, as you know, or prohibit certain economic development activities or opportunities. They really look at sort of compliance or reporting. So if you look at this in the context of lending, for example, we have state laws that might outright prohibit small dollar, high interest loans, or put caps that wouldn't make it worth engaging in the business. But if you look at the federal laws with regard to lending, then they really don't care about caps or interest rate caps or whether it's good business or bad business. They just want to make sure that there's sort of reporting statutes that you're making sure that any loans that you're providing to consumers are transparent to the extent that you understand how much the interest rate is. That's the Truth in Lending Act. Maybe that you don't make loans to military families and things like that. But generally, the activity itself and the interest rates tied to it is legal under United States law. So now we see here sort of that tension. The states might prohibit it, make it illegal, but tribes don't have to follow those laws. The feds really don't care about interest rates and the like. They just want some reporting requirements and compliance, and tribes do have to follow that law. So where do tribes usually fit when that happens? Well, tribes usually enact their own laws that are more consistent with the federal laws without any regard to the state laws, right? And that's why if you look at all the businesses tribes are good at, frankly, where the opportunity exists, it's things like casino gambling, garbage dumps, cigarette manufacturing, pharmaceutical sales, now online lending. And it's not that tribes are just keen to go in those really heavily regulated environments. It's that because of this legal system that we operate within, that's where the opportunities exist for tribes to really seek a market competitively and pursue those activities. And so because that's where the tension is, it's a constant battle of states trying to shut us down at every turn. It's a constant battle of the states trying to say to the federal government, to the courts and everybody else, we need to take their sovereignty away. We need to take the ability for tribes to enact their own laws and govern themselves because it's inconsistent with our state law. We need to figure a way to chip that away from tribes. Okay, so I just want to kind of lay that framework. So I put together a presentation of how I see all this coming into play right now in the context of online lending. And, I just put this together, so I don't know how well it's going to go, but we're doing so many things to fight for the long-term viability of this product. I mean, these lending books have changed Indian country. First of all, this business is in excess of a $30 billion business per year. And because the tribes are such good at managing businesses, we've really managed to take out a nice chunk of that market share, which has freaked everybody out. Anytime tribes start making money or need to start making money, they start to figure out what's going on there and figure out how to stop it. But these businesses I've seen, and I represent tribes nationwide, most of them are poor tribes, and I can't even describe the benefits that I see. Your partner here, your neighbor here at Lagby Gazere, for example, are using their revenues to heat homes this winter. Because I can tell you how cold your winter is and what the cost of gas prices are. But who knows what these tribal members would do if they didn't have this source of income now. I could hit real close to home. Rocky Boy and talk about what the lending book's done there. I've got a nephew that's a manager now that I never knew could hold a full-time job, that, you know, has gone from stealing as little as a nickel off of a coffee table. You know, we used to test him to see if he'd take that nickel, and every time he would, it was kind of a family joke. And now the kid's buying the most beautiful Christmas present for his mother that you would ever imagine, because he has a job and he's got a family, and he's sobered up because of the lending book, and an opportunity that would have never existed if not for e-commerce and the ability for this tribe now to engage in commerce all around the world, frankly. So, you know, this e-commerce notion is worth fighting for. Because, you know, it's sort of like that old adage. I look at the federal government, and they're really focused. Obama's a great president, but they're really focused on just giving government programs to tribes. You know, I'm like, well, where's NCI? They should be fighting for e-commerce too. NCI is busy, you know, with very good initiatives like the Domestic Violence Against Indian Women Act, or, you know, child welfare and the like. I'm not knocking those programs to say that we should always accept that money. But the end result of all those programs are just additional grants. You know, grant money that tribes will spend, and then it's gone. And, you know, what we really need to do with the federal government is discuss how to protect our sovereignty so that we can engage in e-commerce and other economic development. That's a game changer. You know, it's like that Chinese proverb that says, you know, if you give a man a fish, he eats for a day. If you teach him to fish, he'll eat for a lifetime. Well, that's what we need, not additional grant money for domestic violence. We need validation of economic activities on our reservations that provide jobs that can bring millions and millions of dollars into our communities. And that's sort of the dignity that can be restored amongst our people, where they hold down these jobs and feed their families and pay their bills, and they get a very strong quality of life on the reservation. It's very difficult to get the United States to understand that that's what we want to do. But anyway, let's look at the attributes of tribal sovereignty in economic development. And I listed 4 here to sort of make my point. The first one is, like I said, tribes they can enact laws, right? So the first thing that tribes do is authorize the economic development activity. Another one that they can do is incorporate businesses. You know, because they're sovereign, the tribes have the ability to operate and manage those economic development activities that they made legal on their reservation. Another one, the third one that I identified, is regulating those activities. Once you legalize them, once you've got a company that's performing those activities, then you should make sure that you're following your own tribal laws and that you're maintaining compliance not only with those tribal laws but the federal laws. And then another attribute of tribal sovereignty that just is always there, that we all hear about, is sovereign immunity. And that's really the ability for tribes to disallow the exercise of state jurisdiction over those economic development activities, so that when a state comes to tribes and tries to shut them down, you know, you got lawyers, I'm a lawyer, and always argue, well, you don't have jurisdiction over us because we're immune from suit. You know, we have sovereign immunity. So in the context of online lending, this is sort of how it plays out in my mind. First of all, the tribes enact their laws to make the activity legal. So at Lac du Flambeau, LBD, every other tribe engaged in the industry of lending, first thing they do is pass a law that says, well, lending is legal on our reservation. So now you can engage, you can take loans out from an entity on the reservation, and it's a legal act to do. And of course, this is where they don't apply strict interest rates, you know, for example, but they do apply a lot of consumer protection. One thing that we're doing as an exercise of our sovereignty is we've created NAFSA, the Native American Finance Services Association, which is a core group of tribes. There's 18 tribes that are members of NAFSA. The website is mynafsa.org if you want to look at it. And those tribes are focused on working together to protect the sovereign model of online lending. So they do a whole bunch of activities to make sure everything the tribes are perceived as doing is legitimate. A couple of things they've done is recently has created a model code. You know, this model code was taken from the state of Colorado as a template, and they chose Colorado because they had the strictest laws in the United States with regard to consumer protection. So now what you have is tribes, like I said, exercising their sovereignty. They're passing laws, and not only are they passing laws, they're passing the strictest laws when it comes to consumer protection, really in the world. And the reason they do that, you know, I was thinking, well, why do we have to do that? Why do tribes have to pass better laws than even most states? And I was in listening to a professor last week give a presentation in Arizona. His name is Matthew Fletcher. He just published an article called The Unifying Theory of Tribal Civil Jurisdiction. And there were two observations that he made that I just thought were something that we as attorneys and you as tribal leaders need to focus on. The first is, he said, the recent trend in congressional thinking on tribal authority, your sovereignty, is to recognize and reaffirm tribal authority to exercise expanded governmental authority only if the tribe meets or exceeds American constitutional standards. So there's a huge lesson there. The first step that we need to recognize if we're going to exercise sovereignty and pass the law and then abide by it is that if we don't want a state to chip it away, we have to actually exceed the whole world with regard to our law. We have to pass the best laws in the world. And then and only then are people okay with the tribes engaging in that activity. But that's why we put together this model code, you see, to make sure that tribes can pass the model code, and then we're the cream of the crop. We've got the best businesses in the country. Then he points out, secondly, that tribal governments of authority exist because it predates the Constitution. We already followed that. And it has not been entirely extinguished, but expansive tribal authority must be earned. So to think that we can just jump into businesses and engage in businesses because we're sovereign is really something that is dangerous for tribes to do. Not only do you have to pass the best laws and have the most integrity, but you really have to earn that credibility once you pass those laws. So that's the first thing I wanted to focus on. You also have corporate codes which allow you to do what? Well, establish businesses. And again, those businesses, we've got to be careful in how we establish them. They have to be 100% owned by the tribe. We have to use all the profits from those businesses to provide essential government services. And frankly, no other businesses are required to do that, but our tribal businesses are. But you never hear Indians complain about that, obviously, because we're good at that. You know, the reason that we run our own businesses is because we want to strengthen our tribal government and provide jobs and services to our tribal members. That's an easy thing to do, but there's also a lot of mobility in that. And then, of course, our businesses, like I said, we have to earn this credibility, so we just can't run a business normally. But as a business, we have to adopt best practices and follow and abide by those best practices. Again, NASA's come out with best practices, and all the tribes engaged in lending that I'm aware of follow those best practices. And then this is probably the most important one, the regulation. You know, you just can't say that you're going to have this wonderful model code and that you've got these operational best practices, but you've got to make sure that that law is followed in detail. And so what the tribes do is they establish these regulatory apparatus, in this case lending commissions, that ensure that the tribal business is not only complying with tribal law, but they're also complying with federal law. Now notice I didn't say that they're worried that they're complying with state law, because again, state law doesn't apply. But we really need to do a good job to make sure that we are following our own tribal law as well as federal law. Okay? I always say that the greatest erosion of tribal sovereignty is a tribe that doesn't follow its own laws. And unfortunately, as most of us know, sometimes it's really hard to make sure a tribe is following its laws all of the time. And then, of course, we have regulatory compliance manuals and everything else that go along with regulation. But that's really the most important aspect of every, in my opinion, every economic development activity, and especially in e-commerce, because you can't just put these codes in place and point to them, and put best practices in place and point to them. Eventually, you know, you got to pull back the kimono and show them that you're really doing what you say you're doing. You know, that this place is properly structured and it's properly regulated. And then, of course, we've got sovereign immunity over there on the right. And again, I always say that sovereign immunity should not be the focus of any tribe or tribal business or tribal government. It's really a litigation defense, so that if and when you're attacked by a state, then that's your last resort, right? The best scenario is that people look at everything you're doing and realize that the activity is legal, but that doesn't happen all the time. So if they come after your business anyway, and just ignore everything on the left of that dotted line, then of course, and you're being sued, then of course you're going to have to claim sovereign immunity from suit to get rid of that case. But I just point out that's a last resort and not necessarily constructive like everything on the left side of this line. Everything on the left side of this line creates opportunities for tribes to legitimize their businesses at the federal, the tribal, and the state level. So once tribes focus on everything on the left, it's important for them, from my perspective, this kind of goes into the politics of this business, it's important that you start to get legs and get out there and build relationships. I put the CFPB here. The CFPB is the Consumer Federal Protection Bureau. It's a federal agency. It was created by the Dodd-Frank Act. The Dodd-Frank Act was created to protect consumers, because of the Wall Street crash and credit crisis and foreclosure blow up and everything that happened back in 2007, 2008. And, so that, federal government believed there needed to be a watchdog, a police to protect consumers. Well, now they're up and running, times are a lot better, and so these guys don't have much to do, and their focus all of a sudden is on the tribes. They meet with attorney generals, and the attorney general said, what we really want you to do is put tribes out of business because they're violating our laws. And of course, the CFPB, whose top dog is a former state AG, his name is Richard Cordray, he's game. He's like, yeah, let's take care of that problem. Let's put tribes out of business. But the interesting thing about the very statute that created their department, the CFPB, is it's also the federal law that defines state government as a co-regulator and a partner with the CFPB to regulate lending. That same law defines Indian tribes as states. So every time you see the word state in that law, you don't think of the state of Washington or the state of Texas or the state of New York. You should also be thinking of Lac du Flambeau, Lac du Désir, the Otoe, Missouri. And it's important that you understand that states are treated in that federal law as governments, not as businesses, not as deregulated, but as regulators. So you're a co-regulator with the federal government. And that commands respect from that agency. The same agency that's been trying to shut us down and has written briefs in support of state government to shut us down really needs to recognize that we're their co-regulator of this activity. And they should look at our tribal laws, our businesses, and most importantly, our regulation to ensure that we're not violating any federal law or statute. And they really have no business trying to enforce state law on our lands. So we're doing two things with the CFPB. One, we're proposing our model code to them and saying, you tell us what we're doing wrong. And the second thing we're doing is we're giving them a memorandum of understanding and saying, we'll agree to comply with all your federal laws, we'll agree that you can come in and examine our books, and if we break the law, we'll agree that you can come in and enforce if there's, you can take enforcement actions if there are crimes being committed in our tribal lending books. And you would think with that premise that we would make a lot of headway with the CFPB, but it's counterintuitive, but we've completely freaked the CFPB out. They don't want to deal with tribes. They wanted to shut the tribe down. And, it seems counterintuitive that because you're in front of the CFPB and you're proposing all this stuff, then maybe you would get on their radar, but the first thing they do is they no longer even want to look at what you're doing to see if it's wrong or not. Because, they're thinking, well, if they're here, they must know what they're doing. And this isn't our agenda, so let's go find a bad actor where we can create better facts for ourselves. So it's a really dynamic relationship there, but one we're not going to let go of, one that we're continuing to push for.
Also at the federal level is the Department of Interior, which is the BIA, and they not only understand Indian law, but they understand the federal trust responsibility. And so we're getting a lot of lead work done there, where we're showing them, look, we're not sure why the federal government is so keen to shut down these lending books. You know, in fact, we're sharing with them model codes and memorandums of understanding so they can exert jurisdiction over us, and they won't even comment on them with us. We know they won't comment on them because they don't want to establish that government-to-government relationship, which will bolster our efforts in court. But the BIA is interested in that, and now they're beginning to scratch their head and wonder, you know, why is this a bad business? Why aren't tribes allowed to engage in this business, especially if they've structured them right and they're doing all the attributes of sovereignty that we discussed earlier so well? You know, what's going on here? So those issues are just now being raised, and we're seeing a lot of progress. And in fact, it's the BIA that said, you know what you guys should go do is talk to the Department of Treasury. Treasury, as most Indian attorneys and tribes know, has been really effective with all the problems we're having with the IRS. You know, the IRS taxing anything from living assistance to maybe a powwow award. You know, thinking that they should get in there and 1099 anyone who won the fancy dance competition and tax them for earnings. Well, we've made a lot of progress with the IRS to say, hey, you got to treat tribes like governments. You don't tax for state welfare. You don't tax for food stamps. So you shouldn't tax tribes that provide those services to their members. And so we've made a lot of progress, and that's mostly through the Department of Treasury. And now we're engaged at the right level at Treasury with the right people to make all these sovereignty points as to why they should stick up for us in this realm too. We're also dealing with Congress. You know, just like, you know, one thing that I haven't talked about, but you probably see, is what we're doing now is no different than gaming, right? We enact gaming laws to make gaming legal on Indian lands. That's why you have gaming ordinances. Then you create, through your law, a company. That's the casino, right? That's why you have the casinos, and they're 100% owned by the tribe. And then the gaming laws create what? A gaming commission, a regulatory apparatus that regulates the casino, okay? So it's not like we're doing anything novel here. We just understand what the sovereign model of economic development is, and we're just applying it now in a different sector. Well, with regard to gaming, we did it so well that we ended up with the Indian Gaming Regulatory Act. You know, we don't want to do compacts with the states, and I think everyone, including the feds, have learned their lessons that you can't allow states any role. But one thing we're talking about is maybe getting legislation. You know, maybe having the federal government step in and say, look, if the tribes are exercising all of these components of sovereignty so responsibly, why are we letting states attack them? So, you know, maybe it's a good dialogue for us to have with the federal government to seek a federal solution, legislation, that allows tribes to engage in this activity as long as they're doing it right. As long as they have laws that legalize it and they're regulating the industry and they own the businesses, why not allow it? So we're making a lot of progress on that front. And then interestingly, my fourth bullet down there, that's my fifth, is state consultation. Just because state laws apply, does that mean we shouldn't deal with them? The answer is no. What we're doing is aggressively going after state governments. We're dealing with 8 state governments right now to enter memorandums of understanding. And what we're trying to do with the states is say, look, we can give you things that you don't otherwise have. In other words, we don't want to run roughshod over your authority. We don't want to run roughshod or abuse your constituents. Your concern is consumer protection. That's our concern, not only as a sovereign government that regulates this industry, but as good business people who offer best practices. So what we'll do is if state government, if you'll tell us, if you'll send your constituents to our tribal lending agencies, our regulatory agents, we will make sure that we're protecting their interests, that those complaints have proper disposition. And not only will we do that, but if you request, we'll provide you with complete transparency of the disposition of each of those complaints. So, you know, a lot of people might say, well, isn't that aren't you giving up sovereignty there? Not really. Because the state doesn't have the ability to stop the activity that we're engaged in. They don't have the ability to reverse any decisions we're making. We're just giving them the ability to look to see what a responsible government we are, and that we actually are protecting their constituents. Because at the end of the day, we're not harming anybody. These people want these products, we take good care of them. Usually if they default on the loan, most tribes that I know just write it off. So all this concern that we are harming residents of other states, harming the residents of New York or New Mexico or anywhere else, it's just pure hyperbole. So the state consultation is really important. We're even working with a couple of attorney generals that are willing to write opinions to state that everything that we're doing is illegal in friendly states. And then the tribal outreach is important. With NCAI, we have NCI resolutions. You guys know what NCI is, that say that what we're doing is not only legal, but they support the activity, and other organizations. So you might see NASA, what I call NASA propaganda and resolutions seeking support to allow our online lending models to continue. And then, I'll go back over to the right, because this is an issue that we can't avoid, sovereign immunity. And what I put here is that, look, if we do everything on the top level there in a very strong manner, and then we do all the legwork to legitimize ourselves to the other sovereigns, state governments and federal governments, then what we're really doing is creating a strong record, right, of the legality of our businesses. And the whole point there is that if we can create a strong record like we have with gaming, then we wouldn't have lawsuits. We wouldn't have states suing us because they'd have to recognize that the activity overall is legal. So we should just try to avoid litigation to the extent we can. But obviously it's going to come, So when I say, if you break this down to the most basic elements, everything on the left here is, again, sovereignty, right? Notions of good governance, nation building. Now we have enterprises, we have jobs, we have regulations. The tribes are providing an economy for their people. It doesn't matter where the tribe is located, like I said anymore. And then, importantly, there's federal compliance, not just tribal compliance, but federal compliance. Everything that we do on this left side is not in violation of the law. That's the most amazing thing when you hear all this negative propaganda about shutting the tribes down and getting them out of the business. No one ever stops to realize that the tribe didn't break any law. It's such a directive from the feds that we've got to shut them down, but nobody ever stopped. When we've said in the past, I've talked to banks, and the banks have asked federal regulators when they're there, telling them to get out of this business. They said, well, what laws have we violated? And the feds that are in there admit that there are no laws that have been violated. It's just, in their opinion, immoral or unethical for Indians to be giving loans online to people. That's what it really comes down to. And then over here on the sovereign immunity side, we prevail in these cases all the time. Okay? That's what I'm going to go into next. Is we get victory after victory after victory when the states sue the tribes and we claim sovereign immunity, we prevail. All we have to usually do is prove that the tribes, that the business is really owned by the tribe, and therefore that attribute of sovereign immunity is blessed on the tribe, okay, on the company, and then the case is dismissed. And even though those are nice victories, you might be winning those battles, but you're going to lose the war, right? It's because you're winning those battles, but what's really coming out of it are notions of avoidance, not notions of good governance, but notions of avoiding responsibility. Maybe there's just a complete lack, there is this notion that there's a complete lack of state and federal jurisdiction over this activity, and maybe tribes can do whatever they want, right? And then finally, if the tribe's so keen on kicking the case out because there's no jurisdiction, maybe there's no regulation, because you never really get into those facts. And so all of a sudden, all the hard work we did on this side of the spectrum is no longer important, because we can now win cases just based on sovereign immunity. And that's not a good thing, because from a policy perspective, where I see this thing going, and what's happened is, sure, over the last 4 years, we won a whole bunch of cases on the basis of sovereign immunity. But the feds then get concerned because of these notions, and they work with the states, and they work with each other as federal agencies, and they figure, well, how can we get around sovereign immunity? And it's what they always do. They go after the people who don't have immunity from suit. Because remember, when we run these businesses, we don't do it ourselves, right? We have to have software, we have to have hardware, we have to have people going out there and finding leads for us. That's what Montel Williams does, right? I'll watch those commercials. And then importantly, we have banks. We have to deposit our money in a bank. They have to move the money to the customers. There's these ACH, the automatic clearinghouse system, where we've got to move money, you know. And guess what? All of these companies are not only off reservation, but they don't have sovereign immunity. So it's that quick. Well, you know, we made a tactical error as states and as federal government. Let's not go after the tribes. Let's go after the tribes' partners, okay? And that's what they've been doing over the last 2 years. And that's why the businesses are barely surviving, you know. We've seen revenues drop 80, 90%. In some cases, some tribes are out of the business. The Picayune Indian Ranchery in California had one of the biggest businesses, one of the most robust, with $50 million on the street, just poof, gone, overnight. Tribe lost money, investors lost money. And it's because the United States is saying, well, we can figure out sovereign immunity. Tribes, you can go in all the cases you want on sovereign immunity, but we're going to put you out of business because we think it's shady. We think there's a lack of regulation. And how would anyone know otherwise? Because we never even got to the table to show everything that we've done on this side, right? So I just point out a couple things. When you look at it as an attorney, as a lawyer, as a litigator, you know, everything on the left side that we focus on, we put together, is cabazon. Right? That's the Cabazon case about enacting our own laws. You know, we're not violating any state policy. In Cabazon, gambling was legal generally because states have lotteries and states have horse racing and states have bingo. So why couldn't tribes have forms of gambling? Right? Same here. Banks loan money, other people lend money. Why can't tribes lend money? And especially, why can't we engage in those activities if we're doing it right? You know, if we've enacted laws, if we're regulating, if we're doing everything responsibly. So I think we got to focus on sovereignty, right? Not sovereign immunity, but sovereignty. And that's what the Cabazon case stood for. That's why we have the gaming industry that we have now. And what I'm saying is this is no different for e-commerce. We have to follow that same roadmap when we get into e-commerce. If we just stick over here on the right and just wait for people to bring lawsuits to us, then, you know, we're going to continue winning, like I said, but number one, we're going to slowly lose all of our partners. Our expense line items will go higher because we have to deal with shady people or people who recognize they're getting into a risky business and want higher returns for it. But ultimately, you know, you end up with a Bay Mills type case, something that's completely different than Cabazon. As you know, with the Bay Mills case, it's about a tribe that says, well, let's just go ahead and run a casino. We've got sovereignty. We can be immune from suit. We can make those arguments. But let's not necessarily follow, you know, the federal laws or perhaps even, you know, what our own laws were and our own gaming ordinances and everything else. But let's just sit back on sovereign immunity and see if they can win. And as you know, the case isn't out yet, but all of Indian countries are a little worried of what that precedent might look like. Because even though, you know, we can win almost every gaming case along the way, we're finally have pushed that envelope too far, where, you know, we might actually lose a case and erode our tribal sovereignty because of it. So importantly, you know, that should guide our philosophy as tribal leaders and as attorneys going forward with regard to e-commerce. And that's why I say that these cases that we prevailed on, that everybody likes to cite to and argue with banks and others, our cash advance for Colorado, that was cited in, I think, April of 2013. California versus Miami Nation came down in this year, January, just a few weeks ago, 2014. But those are cases that sound real good and say that, yeah, the states can't shut down these lending books. But you have to be careful, because what those cases are really saying is the reason that the states can't do that is because the tribes are immune from suit. Okay? Again, it's the wrong angle to take. And it's why our clients, the Oto tribe and LPD, sued the state of New York. Not because we're afraid that New York has jurisdiction over us and what they might do, but we believe in the model. We believe in the sovereign model. We're not worried about discovery. You know, in LPD's case, I don't think they mind me saying this, they had one bug that was making them hundreds of thousands of dollars a month, but because various licensees violated their own tribal law, they shut it down. You know, that's a strong record to demonstrate that we are better regulators than even the state of New York. It allows their laws to go broken by banks every day. LBD would never stand for that as a good government. So we're not worried about that scrutiny. That's why we filed our own lawsuit. And the reason we filed our lawsuit is because on this side of the equation, on the right, we're going to lose all our partners if we don't do something. We're going to lose our banks, our ACH providers, our lead generators, even our credit reporting companies, because they're the ones that get prosecuted by states. But if we can win a big case like Cabazon and legitimize the industry, nobody can go after our partners anymore because the whole activity is legal. And that's why I try to focus and use this model to demonstrate that, look, we have to earn, we have sovereignty, but we need to figure out ways to make the outside world, state and federal governments recognize that. And we have to earn our place at the table. You know, we can't just win cases on sovereign immunity and expect that we're going to just be able to operate these businesses forever. So maybe that comes off a little defensive because I'm the attorney of record on this case and everyone's asking what I'm doing suing a state. But you have to understand, legally, politically, we have to fight for this business. Okay? We have to fight for this opportunity. One other thing I could say is, if we lose here, if we lose this case, it doesn't take away our ability to have sovereign immunity. You know, tribes can still operate their businesses and no one can stop them until we lose a Bay Mills type case. Conversely, because I get this all the time, well, once tribes lose Bay Mills, you're all done. You know, then you lose. I hear it right from the federal government. And I always tell them that's not the case. Just because we lose Bay Mills, it means maybe a state can sue us now. It doesn't mean we still don't have sovereignty, right? I mean, I'm not afraid of those cases. I say let's go right to it. You know, let's go straight to court. I don't need sovereign immunity. Bay Mills doesn't affect our case. What we're doing is legal. So it's important to understand that Bay Mills, if we lose, isn't the end of the world. You know, and that's why I always try to explain to these lawyers, there's a big difference between sovereignty and sovereign immunity. And what tribes need to do is focus on sovereignty. Okay, I know I'm beating that to death. I talked a little bit about the Dodd-Frank Act, CFPB. We'll just kind of go through some of these. These are some of those cases, right? The Colorado Supreme Court says that the state can't sue the tribe engaged in this business. This is good stuff. I'm not saying it's not. I'm just saying this isn't what we should be resting on. South Dakota, I like the South Dakota case, even though it was another, it was a case where South Dakota ended up having jurisdiction over the guy, Western Skies. I saw those commercials too, right? He's out of business now because he's not a tribe. He doesn't have sovereignty. He was an individual Indian on the res with no laws, no regulation, and figured that was okay. What I like about this case is they beat up on the Indian pretty good and kicked him out of the business and held against him. But there were some good things in there that the court said. One, they held that the loans originated on the reservation because the business is located on Indian lands and the activities are conducted there as well. That's some strong precedent for us on the sovereignty side of things. That's why we got to do that right. And it also held that, you know, in these lending models, we require people that if they have a dispute to use tribal arbitration or come to tribal courts. In this case, held that tribes that do that to their customers, it's not a deceptive practice. It's something that all governments do. So I like this case. And this is the recent one that a lot of people think is a wonderful case, and I think it's wonderful too. But it really is saying the state of California does not have jurisdiction because of the Miami Nation sovereign immunity. But I'll point this out. This is a good thing. At the bottom it said, the court noted that even though the state has an interest in protecting their resident consumers, this interest is not tribal sovereignty. Not tribal sovereign immunity, but tribal sovereignty. That's why we got to do a good job of taking care of the state constituent as a government. This is a side that I just say, look, the tribes really need to do what we say we're doing. We really do need to protect consumers, follow regulations, things like that. There was one other thing that I was telling you. Let me go back to my big model about LBP's case. Right here. One of the key things about this case is, again, we're arguing this in a lending context, right? But it's not just lending that we should be worried about. I mean, make no mistake about it, the tag that we face from the federal government in trying to shut down our banks and ACH providers with respect to online lending is really an attack on the sovereign model of economic development. And that's why I pointed out what the judges said when I was arguing that case 2 months ago. They articulated at the hearing that the lending issues before them are novel. They recognize that. And that's when they went down this road and said, no, this isn't just about lending. We need to really take a hard look at this case. Because maybe the facts in front of us are lending, but this is very novel. This is about tribes engaged on the internet. And our decision in this case would reach far beyond the lending activities in question. That's what the judge said. And then that's when he specifically gave an example that any ruling on the current online lending case will also impact whether a tribe can sell asbestos lace moccasins to non-Indians over the internet. Again, we're not talking about lending, okay? We're talking about opportunities of e-commerce, period. That's why this case is so important. And then the judge went on, and I like the dialogue that came about 2 minutes after that. One of the judges said, well, the United States Constitution, like I said, we predate the Constitution. That's why we're in the Constitution as Indian tribes, okay? Because we were already there. We were there before states. That's why they had to deal with us separately in the United States Constitution. It's called the Indian Commerce Clause. There's an entire section of the United States Constitution that says federal law applies anytime you do commerce with Indians, right? That's why we have all this wonderful case precedent. And the judge asked a rhetorical question. He said, why isn't this commerce with an Indian tribe, taking a loan online? Why isn't this commerce with an Indian tribe? It's electronic commerce, it's modern commerce. I like this one. It's fancy commerce. You know, tribes are getting fancy. But when you sit in New York and borrow money from a tribal lender, you're engaged in commerce with an Indian tribe. Maybe the framers of the Constitution didn't think of that, you know. Obviously there is no internet, there's no technology, so they created this commerce with Indians separate, and that's special, and that to be protected. But did they mean e-commerce? And I think it's silly that we even go down that road. Of course they did. Commerce is commerce. It doesn't matter if it's fancy or not. And that's why we've got to fight so hard for everything on the left, because if we lose this case, then there's no commerce with Indians on the internet. You know, we have special rules that apply to us now that don't apply to anybody else. Okay? Nobody worries about asbestos lace coffee machines, you know, the Procter & Gamble manufacturers or anything like that. But you better worry about these asbestos lace moccasins. It's a very, very standard that shouldn't be applied. All right, just wanted to point that out. I have one other interesting thing to show you. Is, to me, demonstrates the hypocrisy of our federal government trustee. It's supposed to be our co-regulator. And that's right here. This is an Inspector General report that just came out January 27, 2014. And I couldn't believe when this came out. It says, providing non-bank financial services for the underserved. And they wrote a report this thick, a white paper from the federal government, the Inspector General wrote it, that says, you know what the federal government should do because the post office loses money every year? We should offer small dollar loans. We could put lending operations at every post office. Post offices are located in poor communities, and we can make small $300 loans to poor people all across the country in every state, and the state laws wouldn't apply because we're the federal government, and we could do it responsibly as long as we pass our own laws and regulate the industry. I sat there and scratched my head and said, man, they must have visited our NAFTA website. That's what we've been saying, for 5 years. That there's a market there. We didn't create the market. There's a real need for these people. These people should not have to go to brick and mortar, those bright pink and bright blue buildings to get $300. They should be treated with dignity on the internet, with governments that are regulating these businesses and offering good terms. We were filling in that gap. The United States is the entity putting us out of business by going after our banking partners. And the same time they're putting us out of business, they're trying to get into it. They're taking it from us. And the senator that is most against this, Elizabeth Warren, is the same senator that supports this. In the white paper, it says, this is a good thing for consumers. It doesn't reduce the demand for those financial services. The United States Postal Service could slide into that space and meet that need without preying upon those communities. Exactly what the Indians are doing. Exactly what our tribal governments are doing. And just, to me, it demonstrates the hypocrisy of this government. Now, one thing that we're working on, and that's why all those efforts that we're doing in D.C. are so important that you see now. But one thing we're trying to do is figure out how the tribes like the Flambeau and Lac-Mégantic, can, if the feds do this, then they're going to obviously have to contract with people to operate the businesses. And it needs to be the tribes because we're already operating these businesses. So we're going to figure out how to get in this market, even if the federal government tries to slide into it without us. They're still going to have to work with us, in my opinion, because we're going to situate ourselves in the right place. I think that's it. Yep. So, any questions? No, I don't know where a lot of stuff there.
I have a question.
Sure.
I'm Peter Gazette with Frontier Financial Group. Over the last 18 months, several of the CFPB enforcement actions against Main Street issuers have been basically drilled down into the UDAP bucket, where they found, for example, Capital One didn't necessarily violate any laws, but the practices on the ancillary services they sold to the consumer were defined as UDAP, and that supported the Capital One enforcement action. So in this slide that we were talking about, on the left side and the right side to us today, although your business model for lending doesn't necessarily violate any laws, do you foresee or do you identify any risk that the CFPB may identify your business practices as UDAP? That's the first half of the question. And the second half of the question is what kind of actions or policies or self-regulation efforts you guys do proactively to avoid being looped into that UDAP bucket?
Well, that's why, there's a few things. First of all, under the incorporated businesses, we point out that we have all these lending best practices, right? That's why the South Dakota case is good too, to say, for example, the fact that they took a hard look, not just at the jurisdiction provisions that the consumer has to come onto the reservation to dispute a problem, but they looked at the whole thing, entering the contract on Indian lands, full disclosure, and that court ruled that those are not deceptive practices, okay, with regard to UDAP. Now, I see what the feds are doing, and what they're doing is tied to this. They're saying, okay, well, maybe you have this, maybe you believe, tribes, that you're not violating any federal laws. And that's why in our model code, one of the provisions, again, to your point, and I'm answering your questions all at once, there's a section in that model code, I think it's like 5.1 or something, we can circulate it if you guys want to see it. It requires compliance with every federal law, whether or not it even is applicable. Because tribes are comfortable voluntarily complying with all federal laws. So what the feds are doing then is saying, well, you might think you're violating you're complying with federal laws, but when you violate a state law, a usury rate, then that's an illegal loan. And because at the state level they think it's illegal, then we have an interest because now there's laws being violated which challenges the legitimacy of the loan, which is a deceptive practice under UDAP. That's sort of the way they're training that. All I can say is, to me, that has no merit. The reason that the law is not illegal in the state is because the state law doesn't apply. You know, our contracts follow UDAT to the T, our best practices, our model codes, and the state doesn't have jurisdiction. That's the 250 years of precedent that you know, the United States is having a tough time overcoming. What's interesting is every time that issue comes up at the CFPB in a correspondence to us or a brief, when they supported the state of New York, the allegations there, but there's zero analysis. There's zero analysis, there's zero legal authority, it's just a conclusion. And that's why we're challenging the state of New York, because we have to prove that there is no UDAT violation in this. And that's an issue that I can tell you they're raising, but it's not been settled. And in fact, there's overwhelming precedent against any kind of claim like that sticking.
Thank you.
Can you give us any update on the New York case?
Yeah, I could. So we filed a lawsuit. One of the things we asked the court was to give us a preliminary injunction and restraining order to keep states and feds from doing exactly what the gentleman just said, threatening them, telling them they're breaking laws or anything, until they can determine whether this is legal or not. So we haven't gotten to the merits yet in this case, whether this is legal or not. And I can't wait to get to court. But, you know, when you get lawyers involved, there's all these motions and interim decisions, you know, this case will probably take 7 years to sort through. So what happened is the New York judge said, I'm not giving you a preliminary injunction. In other words, I'm not stopping the states or anyone from trying to shut your partners down or making them threats that you're talking about, because the way I see it, the resident is in New York, therefore New York should have jurisdiction. And the problem with that is he didn't look at any of the federal Indian law that stood up here for the last hour or whatever we're talking about. He didn't look at all of the sovereignty and the governance that is exercised with great care in making that belong to the New York resident in the first place. So we had to appeal that. So we appealed that to the Second Circuit. That's the hearing I was talking about. And I think the appellate court thought it would be a slam dunk. So first of all, I can tell you, we haven't lost the case, right? I mean, this is just a preliminary injunction. We weren't given it. We haven't gotten into the merits of the case. But then when we went to the appeals court, you know, we went under on an expedited basis, which means they have to hurry, because even as the court recognized, the tribes are bleeding out. They used those words. You know, we are concerned that the tribes are bleeding out. It doesn't seem right. So I thought that hearing, I think, was on November 6th or 7th. I thought we would get maybe a ruling before Christmas. Nothing has come. Now we're in February. Still don't have anything. And the more I think about it, the more I realize, especially when you look at our brief, our reply brief that we wrote, we packed, you know, 200 years of Indian legal precedent in 30 pages. And when we were done writing the brief, I barely understood it. I can just tell you that. Nothing else could go in there, but nothing else could come out, because we had to make every argument and walk the court through all of the Indian law tests, this thing called the Bracker test and everything else, so as to why the state doesn't have jurisdiction over these loans, right? And I was like, man, this is either going to go over the court's head or they're going to really look into it. My hope is that the court's really looking into it, that the judges are taking it serious. They've probably got law clerks wondering if the brief is a bunch of BS or if it's real, if this is what the state of the law really is. And I keep thinking the deeper these clerks go, the more they realize that this model is legitimate. That not only does the tribe have an interest in these loans and that we're protecting consumers, but the feds have an interest in these loans, and that their interests outweigh the interests of any state government in exercising jurisdiction or stopping these loans. So the more I think about that case, we're going to get a ruling. Maybe we'll get one today, who knows? But I'm starting to think that the ruling's not going to be black or white. I don't think that, I hope that the court doesn't say, well, New York was right, we're not stopping any enforcement efforts, you can still go after Indians and still try to shut them down. So we're affirming the lower court, preliminary injunction denied. I don't think it's going to be that simple. I also don't think that we're going to be so good that a judge, that the court, the panel would say, lower court reversed, these tribes are likely to prevail on this case, we're issuing a preliminary injunction, everybody has to leave them alone, they have to be able to run their businesses with their partners, there are no violations until you can prove that that this sovereign model is wrong. You know, that would be tremendous. I don't think it's going to happen. I'm starting to think maybe there's a middle, you know, it's not black or white, maybe there's something in the middle, and the court might do something like, you know, lower court, we don't think that you should have denied a preliminary injunction based upon the fact, simple fact, nothing else, that the New York resident lives here. This is more novel, it's more complicated than first blush, and therefore we're remanding it back to you to reconsider whether or not to issue a preliminary injunction after you've applied these tests, these Indian law tests. Or maybe they're applying the Indian law tests and maybe not going to give a preliminary injunction. But there's probably going to be something in the middle there. Depending on what that is, you know, it's going to be really, if we can get any kind of favorable type ruling like that, even a middle ground, it's going to be a tremendous benefit to the sovereign side of this equation. You know, it's going to give validity and new life, I think, to our businesses. So that's what my hope is, and that will be coming down any day. Yes?
Do you foresee, I know that, you know, we can argue on sovereignty, but also on the definition of APR and how it relates to short-term lending. For instance, if somebody should be a customer and they borrowed $500 and they took maybe 4 weeks to pay it back, if they're a one-time borrower, that APR generally wouldn't truly apply to that person, if you would. Do you understand where I'm coming from?
Yeah, and I think,
They take that short-term interest rate and then they blow it out over, you know, over 12 months.
it's like a optics problem that we have. I mean, what he's talking about is, you know, the way the Truth in Lending Act, which we follow, it says when you calculate an interest rate, it's just not the 35% on the loan. But if you take $300 and you add in $50, maybe it's 300%, right, or 350%. And there's a couple things with that. First of all, that's not illegal. You know, there's no federal law that says you can't do that. You know, maybe that's illegal in the state, but we're not making loans in those states. We're making those loans on our Indian reservations. That's the whole argument. And we're monitoring it. So that's the first thing. But the second thing is, you know, that argument could be made for every bank out there. I mean, shoot, I lost all my money in John John's Casino last night at LVD, and I went to go get $200 more out of my credit card, and I got charged $65 for that transaction. So what's the APR on that?
What's the difference?
2,000% maybe? And to the extent I probably overdrafted my bank account, there's an additional $35. Now the bank probably made 2,000% on me too. So it's just a really unfair standard. It's something that we try to point out, you know, everywhere we go.
So I apologize if that was somewhat of a loaded question, but following up with the white paper, and these laws would exist in the United States post offices. I don't see how that would make them different than what we're doing.
It doesn't make them any different. They just feel that because the federal government's doing it, maybe has more integrity, I guess.
So if the states maybe would follow that, if they were to come to fruition, the states would follow that, would do you maybe foresee an argument of opening those states back up down like that?
I mean, that kind of goes right to this whole issue of, you know, there's a real market here, okay? And I just read a really cool article yesterday that said that the CFPB is actually having an opposite effect of protecting consumers by trying to shut all this down. Because these people need $300 to fix their car or pay for a medical expense or do whatever. They're not going to get it from a bank, they're not going to get it from a credit card company, so where do they go? Well, with the CFPB, you know, forcing everybody out of business and increasing their capital costs, they're making it harder on the consumer, not easier. So you're kind of just, I like your question because you're stating, well, what's the solution then? I mean, why don't states realize there's a need and find a solution? And maybe they are, And maybe that's why they don't like to see the tribes filling that gap. Maybe the whole world, including the feds, recognize that the tribes figured out the solution. You know, the tribes were not only, you know, we got into this business with a model that kind of already exists, but the first thing we started doing right away was evolving the model, figuring out how we could engage in more of the operating expense side of the equation to take more of those activities on ourselves and reduce cost of the business, maybe find cheaper money, reduce cost of the business. And of course, what will we do with all that savings? We'll probably pass a lot of it on to the consumer so that we can give them a better product. And I think once everybody figured that out, we not only made consumer groups mad because we're giving loans, but we got states angry, we got banks angry, we got brick and mortar, the crooks angry. We got the whole world angry almost overnight because we were offering a credible solution that the states probably recognize and clearly the United States recognizes. So, you know, I'm with you.
I know I'm preaching to the choir on that, and what's really bothersome is that they bear the argument of tribes are the reason the federal government recognizes the treaties for the tribes and supports them to be self-determining, self-sustaining, is that when we do figure things out like this, that right away everybody else is going to jump out and regulate something, and it just goes right against, supporting the tribes organizing and determining themselves.
Yep.
Well, a comment and a question. The comment is, there are or were a lot of bad players in this market, not necessarily the tribes. And they're taking a wide net and casting it over everybody. But there were a lot of people that took advantage of this and were abusing it. And those people are falling out. If we can get to a mediated resolution with the better players left, it'll be a better, bigger market.
I agree.
So
That'll include the tribes.
right. The second comment, though, is Operation Choke Point is a coordinated effort between all of the branches of government. What stops DOJ and the FDIC from continuing to shut down? And we've had it here a couple of times, banks doing business with us.
I think it's the legitimacy of the business. We have to do something to legitimize the model itself. That's why I'm saying, I think the lawsuit in the state of New York is a start, but we should have a lawsuit in the state of California where Cabazon was won in the Ninth Circuit. We should have a lawsuit in Oklahoma where they understand federal Indian law, and of course we have all the favorable Class 2 gaming precedent because it's the same model. But if we just sit back and continue to argue sovereign immunity, the banks are going to realize, well, that doesn't protect them. And maybe we pull out tricks out our sleeves, like say, well, it's, we're an indispensable party and we're not included. Well, none of that solves the overall problem. And the only way to solve the overall problem is kind of what this presentation was aimed to do is, first of all, make sure that we're really doing it right. That we know that we're not violating any laws, that we know we're offering good products and following best practices. But then, once we've laid all that foundation, then we've got to go out and establish the precedent. We've got to file the lawsuits. And that's what I think we've got to do. And unfortunately, when I say that, especially to lenders and tribes, I just think I'm trying to create billable hours. So we've got tribes engaged in New York, which is the best location to bring a suit. But, I believe strongly that we need to file similar suits in California and Oklahoma and get those moving in the right direction too, because we've got big facts. We have states that are putting us out of business by going after our partners for legitimate businesses, and not only are legal under tribal law, but federal law, and we have a federal interest there that needs to be expressed to the courts. So I don't know if I answered your question.
Yeah, you did. Just a follow-on question. You've got a very aggressive agent like Lawski in New York. He's now gone against Money Mutual Partner Weekly, trying to get all of the providers information, meaning everything. What's your position on giving that information to New York State?
Well, so I have some specific positions. One is the discoveries in the state of New York, so they can't get that from the tribes who are engaged in the litigation. So, we're explaining to the judges there that They're circumventing the discovery process, for those clients. With the other clients, and this is some positions we've taken, we think, part of the sovereign model is your ability to regulate your industry and to run your businesses. And so you have the ability to issue your own protective orders at a regulatory level that are inconsistent with the state and maybe even inconsistent with feds. We've issued orders that contradict court rates demands and orders and said, well, and even though they're all real keen to say, well, we're going after the business, well, it's easy. We have our regulatory agency intervene and say, well, the business isn't allowed to provide that to you because we're issuing our own protective order because you're violating our ability to run our businesses on our Indian lands. And that's a huge legal issue. Some of the partners are okay with that, and they're hiding behind that. Some of them are like, well, that's not good enough for us. We'd rather not respect the tribe as opposed to not respect the state. In those cases, what we're doing is we're issuing orders allowing them disclosure of the information to the states so it doesn't erode our sovereign arguments. And in many cases, we're issuing the same discovery and disclosure of that information to our tribal regulatory agencies so that we can provide it to the state first, or the feds first. Again, demonstrating good governance and creating facts so that people can't attack us, from this whole notion that there's a lack of regulation and lack of jurisdiction here. We want to be players in this industry is what I'm saying. So everything the state and feds do, we either need to prohibit or prevent, and to the extent we can't prohibit or prevent it, we need to give it our blessing at a government level so that we don't erode our sovereignty. And those are all strategic issues, but I'm sure we could have offline conversation about all that. Is there another question?
I guess I'm Melissa Dowd, and I'm the call center manager for our internet here in Flammable.
Okay.
And I guess some of the things I'm thinking about is not just practicing the tribal sovereignty, but it's a business that's not going to go away. So our partners on Florida are vigorously pursuing other avenues of approach to keep us afloat. And at the same time, with the FDIC and everybody hovering over us, the feds, trying to, the chokehold, to choke us out in the ACH processing and the banks and, like you said, go after our partners. I guess what I'm trying to say is that I think they see that there's revenue to be made, which is why, the articles with the post office, now they're going to be offering those types of services. I guess what I'm thinking about practicing the sovereignty, what can we do to stay within regulations and boundaries and everything, but to stay a step ahead of them as far as, like a credit of our own, and trying to stay ahead of the game, partnering with the ACH to remain sovereign.
Yeah.
What types of things have you seen?
Well, so that's why I was saying, the good thing about sovereign immunity is because ultimately states can't shut you down, right? But like I said, unfortunately for our partners, they don't have sovereign immunity. So to your question, to the extent tribes get engaged, not in just, like you said, call center, maybe lead generation, marketing, ACH, maybe even a bank, tribal chartered bank. Well, then all those entities would have sovereign immunity. So you could evolve the models, I think that's what you're asking, you could effectively evolve the model so that, they can't shut down their partners because they're owned by tribes too. And that's something I think that we're all exploring vigorously. The gentleman in the back there commits his life every day to that, John McGeeshik from LBD. He works on that every day trying to figure out how to solve all of our legal problems by, turning everything into a tribe.
We're going to have these same battles going into the gaming side of things.
Are you talking like internet gaming? Yeah, see, that's why this is also important now, I think, is that we've got to, this lending case really goes for any e-commerce, and internet gaming is part of that. You know, well, this guy lives in New York, so we shouldn't let the tribe take his money to play bingo. You know, that's exactly the type of analysis that we're fighting.
Real quick question, since we have you up there. Briefly, setting of cigarettes. If a tribe, do you know if there's any movement on a tribal level where it's easier for tribes to purchase setting of cigarettes and bypass the preferred vendor listing in states? They be able to sell setting of cigarettes? The tribe purchasing tribal assets?
But I guess I always subscribe to the model of one of the reasons this whole model works is because the tribes have the laws on the reservation, and then they got all of the raw materials, if you will, in this case money and the software to qualify loans and everything, and they created that product on the reservation. They added all the value. The product wouldn't exist except for what occurs on Indian lands. So I think that analysis really comes from, you know, a lot of the cigarette precedent as well, that, look, if the tribes are creating all the value on the reservation, not growing tobacco, but pulling all the raw materials together, and they're manufacturing cigarettes, it's more of a manufacturing issue, not a distribution or retail sell issue. But they're manufacturing the cigarettes, pulling all these raw materials off the reservation and creating the product, then the states have no interest in regulating it. The states have no interest in taxing it.
And so it leaves the,
You know, so you can, as you know, I think, tribes can sell cigarettes without a state tax payment to Indians or non-Indians, as long as the cigarette was manufactured on the reservation, because that's where the value added came into place. That's where the tribal interests are outweigh the state interests with regard to the regulation of that cigarette. And, you know, to the extent that the tribe had an ETF license, alcohol, tobacco, firearm license, not every other federal statute has been complied with. Not only is there a federal interest with regard to all the compliance with federal law, but then the feds have a trust responsibility over the tribes to protect that economic development, which outweighs any state interest. So that's why you can, have those situations where you can't sell cigarettes without a state tax payment to a non-Indian. So, it's a lawyer answer to a question, but to me, it all depends on how those transactions are structured. But that's why we have to fight all the time to make sure that we don't lose that recognition as a government, that interest as a government, to create those products on our Indian lands and keep state jurisdiction out of it.
and the kicker is what I'm looking at, for instance, aside from like if I'm looking at maybe if it is in the future viable to manufacture and sell their own cigarette brand. But for instance, if we wanted to purchase cigarettes from Oklahoma, the Seneca Nation, or Nebraska, whatever, Oklahoma chunk, there's an Indian commerce, isn't there, an Indian commerce law or act or something where the tribes can purchase goods and services from one tribe?
There are.
But there's transportation situations in between them.
There are arguments for that. Yeah, that's, again, I agree with it, with everything you're saying, but it's not necessarily settled law, but, you learn when you get into the nuances of all that, there's all kinds of ways. We learned that the Yakima tribe, for example, actually has a treaty right to move cigarettes, any good, without any state jurisdiction. So they can move cigarettes from tribe to tribe and not be violating any laws, federal, state, or otherwise, because of their treaty right. And we learned that treaty right not only goes to the tribe, it goes to individual Indians. That's why Yakima is getting into all this transporting business now. So there are just a lot of good, cool ways, but we don't want to conflate the issues.
Yeah, I just wanted to steal the 5 minutes.
I could sit out here 10 hours and talk about all this stuff. Anything else? Well, thank you for inviting me. It's nice to be here.
Thank you, Rob.